I appreciate the opportunity to be here and talk with everybody about estate planning and advanced directives. My name's Joel Cavanaugh. I'm an attorney in Akron, Ohio. I practice out of Fair Lawn, Ohio, is where my office is. And I specialize in estate planning, among other things. But for purposes of today, we'll talk through estate planning. Typically, when I think of estate planning, I think of it as a two-sided coin. The dividing line tends to be whether the person is alive or whether they've passed away. But on either side of the coin, we're really trying to address important issues that may impact all of us. On one side of the coin, we're focused on what happens when a person passes away to their stuff. How does it get from them to their beneficiaries, and what's the best way to do that? Typically in that realm of estate planning, what we're worried about is, do you have a will? Do you need a trust if that's something beyond a will that would be helpful? And we're focused on ownership of assets. Typically in this area, when a person passes away, the most important two questions that I'll ask as the legal person behind the scenes is, what did that person own? And how did that person own those assets that they owned? We'll get into that in this discussion today, but generally speaking, that's one side of the coin. The other side of the coin, which is equally important, comes into play while a person's still alive, and we're trying to address issues such as, what happens if that person can no longer handle their finances? They have some kind of incapacity or disability that prevents them from being able to pay their monthly bills or file their yearly tax return, or even simple things like update license plate stickers. And for financial matters or medical matters, we're worried about, what happens if you can't consent to certain procedures, but you need surgery, or you need more medication, but you don't have the wherewithal to make those decisions yourself. Typically on that side of things, we're talking about documents like a financial power of attorney, sometimes also called a general durable power of attorney. And we're also thinking about a medical power of attorney and a living will. So we'll get into some of that as well. With estate planning, one of the hallmarks is that I always tell clients, it's much simpler to deal with someone passing away or someone becoming incapacitated to manage medical and financial decisions if we have documents in place. Proper documents like a will and medical and financial power of attorney allow us to prepare for those contingencies and allow us to pick who would help us during those contingencies. And that tends to make things a lot more efficient. And it gives you a lot more control over how those situations are handled. Without having estate planning documents, it's not as if those things won't be handled. It's just that you're relying on state statute to determine who would be in charge of handling medical and financial decisions, or where your assets would go if you pass away without a will. So not everybody needs a trust. We'll get into why that is a little bit later in the discussion. But everybody should, at a bare minimum, have a will, a financial power of attorney, and a medical power of attorney. So while we get into it, the first side of the coin that we'll talk about are the powers of attorney. So more often than not, we tend to handle our financial and medical decisions are on our own. We don't really need somebody to step in and be able to handle that for us. But if you get to a situation where you can't pay your bills, I'll often joke with clients and say, imagine that the gas company sends you a bill and you're in a coma in a medical bed somewhere. You can't pay that bill. It's not as if we could tell the gas company, hey, Sarah's a vegetable lying in a hospital. She can't pay her gas bill. Why don't you come back in a month or two and we'll let you know? The gas company may listen to you, but ultimately they're just going to end up yanking the gas out and not giving you any monthly service anymore. So having a financial power of attorney in place allows you to appoint an agent that can stand in your shoes and make financial decisions for you. really that's what a power of attorney in general does and is. It's a legal document, and it's based on the principal agent theory in law. A principal is someone who can appoint another person to stand in their shoes and make decisions on their behalf. Um, the financial power of attorney is often called a general durable power of attorney over finances. Um, and it allows you to pick anybody that you select to be able to stand in your shoes and pay bills, deposit checks, file tax returns, and handle anything that you would need done. In Ohio, our financial powers of attorney end up working on two different levels of authority. So within the power of attorney document, you're able to grant as much authority as you deem appropriate for your agent to handle. So we have certain pieces of authority that are called general authority, and we have certain pieces of authority that are called extraordinary pieces of authority. Um, I always think of financial decisions that we make on a spectrum. And as far as the financial power of attorney goes, we typically want to give our agent enough flexibility to step in and be able to assist us without giving them the extra leeway to take away some of our assets or alter how we hold those assets and how they may ultimately pass. So, general authority allows an agent to do what would be reasonable along that spectrum if you had done it yourself. So, I'll often make the joke with real estate and say there's a lot of different things you can do with your real estate. And if you have a financial power of attorney, you're including your agent you name into some of those activities you could do with your own property. So I'll tease and say, if you were going to church this Sunday and you're sitting next to a friend in the pew and you told them, hey, I sold my real estate, they would look at you and say, cool, how much did you sell it for? If you said, hey, I leased out my house and I got a tenant now, they'd say, cool, how much are you getting a month? If you said, hey, I gave my best friend my property and I paid them $5 for taking it off my hands, everybody in the pew would turn and look and say, wait, you did what? Right? So under that general authority, your agent would only be able to do what would be reasonable. So they could buy, sell, lease, or mortgage real property, but they couldn't give it away. For the extraordinary authority, you can empower your agent to have some pretty extreme abilities on your behalf. Things like creating a trust for you or changing the terms of a trust you already have, giving away your assets if that makes sense, all the way to changing beneficiaries you've designated, and so on. So it's very important to have a financial power of attorney. That way, you have somebody that's in place. Um, Without the powers of attorney in place, and we'll get into in the next couple slides what the medical power of attorney is and does. But generally speaking, without a power of attorney, your financial and medical decisions still need to be made. And the Ohio law defaults to the probate court, and the alternate to powers of attorney is a system called guardianship. I'm not sure if anybody out there has ever had to deal with a guardianship, but essentially, a guardian is appointed by the probate court and empowered with the ability to make medical and or financial decisions for an individual, and all of that is overseen by the probate court. So to put that in practical terms, I had a lady I was working with not too long ago. She passed last year, sadly. But for the past 3 years, I was her legal guardian for both financial and medical decisions. Um, as she aged and as her care level became more in the nursing home, she got to a point where I had the nursing home call me and say, hey, we're at the point where she needs somebody to go out and buy her a pack of Depends. Happens. She's older. Through a power of attorney, had I been named as her financial power of attorney, that's a simple task. I go to Walmart, I pick up a pack of Depends, I drop it off at the nursing home, and life goes on. Through a guardianship, however, I'm not authorized to spend money until the court gives me approval. So I get off the phone with the nursing home. I draft a legal document that I file with the court saying, pretty please, may I buy this lady some Depends? And then I wait a couple weeks for the court to issue a ruling that says, well, yes, of course, you can go buy her Depends. And so then after 2 weeks, I get that order. I go to Walmart. I spend her money to get the Depends and I drop them off. Then I give the receipt to the probate court and say, see, I told you I spent the money on Depends, just like I said I would. And then at the end of the year, I have to reconcile every penny that came into and out of her account so that the court knows that her funds are being spent appropriately. Um, I don't know if I conveyed it just in the way I told you, but that is a horribly inefficient way of doing things. And you figure I am an attorney, believe it or not. So every single minute I spent on that, she was getting billed for. So at the end of the day, it ended up being about $1,000 box of Depends. That it's so easily avoided if she just had that power of attorney in place. And it's the same thing when it comes to the healthcare power of attorney. Without naming who would stand in your place and make medical decisions for you, the court is going to appoint someone for you. And that may be your family, but it may be somebody like me. Um, and that tends to be kind of awkward because I had another guardian case where I was the gentleman's guardian. And I got to know him a little bit, but typically by the point I'm the guardian, the person I'm working with really doesn't exist anymore. I mean, the lights are on, but there's really nobody home. And so I don't really have a background on this man's religious preferences or personal preferences in regard to medical treatment, especially end of life care. And so I remember it was Easter of 2021, and he had gone into the hospital. And it was literally Easter Sunday. I got a phone call in the evening that said, hey, Tom's not doing so well. We need somebody to make the call to pull the plug. Can we have your consent? And very awkward to have a third party stranger make that decision for you. And again, that could have been alleviated by just doing a medical power of attorney, which is a very simple document to do. So that's the next document that we'll get into. So that's because it's a power of attorney, it's still a document where you're appointing an agent, and that's someone you select. An agent is such a sterile mechanical term, but think agent of your family members you'd pick, mom and dad, or your husband or your kids. Those are really the people making medical decisions for you. A difference between the medical and the financial power of attorney is that typically the financial power of attorney is valid and enforceable and effective the minute you sign it. So whether you're competent or incompetent, that financial power of attorney is going to give your agent the ability to act on your behalf immediately. The medical power of attorney differs in that your agent can only make decisions for you if your treating physician has determined that you're not competent to make those decisions. I think that makes a lot of sense with the medical power of attorney. I always tease my wife. I was explaining to her why that made sense. And it was like the financial power of attorney. My grandfather got to be, 83 and decided he was giving up on paying his bills. And he wasn't incompetent, did crossword puzzles till the day he died, but he just didn't want to pay his bills. Now, if we had waited till he was incompetent, he wouldn't have had that option. But my mom was able to pay his bills and handle all his tax returns, no big deal. The medical power of attorney, and I was explaining this a bit to my wife, it's a bit problematic when you can make your own decisions or an agent can make them for you on the medical front. I teased her and said, well, would you like to get big lip injections? Because I think you'd look fantastic if you had just giant lips. And she said, no, why would I ever do that? I said, okay, well, if I'm your agent under a medical power of attorney, and we both can make that call, you're getting lip injections, right? So it makes sense that only the agent can make the decisions after you're incompetent. But medical decisions in this document range along a really broad spectrum. In the current iteration of the Ohio form, on the lowest end of the spectrum, we have a HIPAA release. So I understand a lot of folks on this are in healthcare or have some healthcare ties, right?
Now, these are all city employees, Joel, so...
Oh, great. Well, then don't worry about HIPAA. It's a stupid federal law. But it prevents your physician from really disclosing any information to anyone under any circumstances. If you've ever had to deal with a medical issue with a spouse, I know personally, my wife went to South Carolina without me and ended up in the ER for a day. She got dehydrated. And when she got back home, I tried to pay her medical bill. And the nice young lady on the other end said, "We can't talk to you. You're not Rachel." And I said, "That's okay. I'm just paying Rachel's bill." They said, "Well, we can't disclose information without Rachel being present." "That's fine. I don't need information. I want to give you my credit card." So, "I'm sorry, sir. We can't take that. HIPAA law, prevents us from doing that." "Okay, then I guess you're not getting paid," right? So in the document, there's a HIPAA release. So it allows your agent to get information from your physician and for the physician to be able to freely share that information, which the more information somebody has, the more likely they are to make a better decision on your behalf. Then from there, your agent under a medical power of attorney can also consent to medical procedures or medical treatments. They can get home health care for you if you're in that boat. They can make the decision of whether to move you into a long-term care facility, all the way through to the most extreme end of this document, which is you're permanently unconscious. You're not really going to ever have hope of waking up. You can authorize your agent to have the authority to communicate to the physician that you'd like them to withdraw the artificial and nutrition and hydration. So pulling the plug essentially is what we call it. So that's what the medical power of attorney does. And the only other document we talk about on this side is a living will. So a living will is a document where there's a lot of confusion around it. Some of it is because in the umbrella of estate planning, we have a document called the last will and testament, and then we have a living will. And so why we would name two different documents in this area a will, it's something only a lawyer can come up with, right? Just confuse people as much as possible. But the living will has nothing to do with your last will and testament. And most people think that it works in tandem with the medical power of attorney. In other words, like you need both documents and both play off each other. It's actually quite opposite. So the medical power of attorney, we had talked about giving an agent the authority to make all kinds of medical decisions, including whether we pull the plug. The living will overlaps in the time period where you'd be terminally ill or permanently unconscious. Essentially, the living will, and oftentimes it can be called an advance directive, is you making decisions ahead of time for how you want the physician treating you at the end of your life to treat you. Typically, it's limited to that space. And in that document, you can also elect to have the physician have the right to pull the plug. That's where these documents diverge. Under the medical POA, you're saying, I want my agent to pull the plug, which typically would be your family members. Under the living will, we're asking the physician to make that determination and to carry out that request. And that's regardless of what the family decides or desires. So I live in two different worlds most days. I live in legal and practical, and the two don't often see eye to eye. So from a legal standpoint, having both a medical power of attorney and a living will sets up a scenario where if the plug has to be pulled, the living will takes priority and the physician gets to make that decision. The actual document, and I'm a nerd, I didn't give you a big bio, but I'm an English major, and then I went to law school and became a lawyer. So I'm double nerdy, and I'm really interested in words, particularly. So the living will would say, I direct my physician to pull the plug and to make his or her best efforts to communicate that decision to my family. So um, the living will can be pretty extreme if you don't know what it does. And I always wonder, what are the best efforts? We don't really have case law on that, but I'm waiting for the case to come out. Like, well, the doctor texted her twice, so that's reasonable. Or, is like a fax and an email okay together? But the main takeaway between these documents and how I differentiate them is if you prioritize who gets to make that final call to pull the plug and you prefer that decision to be made by your family, you likely don't need a living will and shouldn't have one. If you prioritize that the plug gets pulled and you genuinely don't care who does it, then a living will should be part of that estate plan when you create it. I think of my parents in that regard. When met with that decision, my mom said, why would I want the doctor making that call? I'd rather my family make it. I can talk to them ahead of time. They'll know what my wishes are. So I'm comfortable, even if I'm kept alive artificially for even a couple months, that my family gets that decision. My dad was on the other end of the spectrum. He said, I don't really care if the janitor pulls the plug. Just turn the lights off on the way out and leave me be. And so dad has a living will because that's his primary piece of import there. I think, Sarah, will we have time for questions at the end?
Yeah, we're planning on it. So.
Okay, cool. So that's in a nutshell how powers of attorney work, how the living will fits into that first side of the coin. And again, what we're really trying to address there is if ever there's a time where someone's got to make decisions for you, how are they making those decisions and what kind of authority do they have? Is it an easy swap like the powers of attorney provide? Or are we going to have to maybe go through the probate court and maybe, tread a more difficult road there? So next will be going through the other side of the coin. And typically this is what leads more people into my office than the other side. People are more often concerned with, okay, when I die, what happens? How does my stuff get to my beneficiaries? Who are my beneficiaries? And what's the best way? Should I get a trust? Do I need a trust? And so on this side of things, we're really concerned again with what your assets are when you pass away and how you own those assets. There's a distinction between probate property, which necessarily passes through a will and necessarily goes through the probate court, versus non-probate transfers or non-probate assets. And we'll get into all of that as we go forward. So the main document we use in this area is called a last will and testament. So a will controls who receives your property when you pass away and how that property is passed. The will communicates directly to the probate court, and any asset that is a probate asset goes through your will to the beneficiaries listed there. Um, some of the benefits of having a will are that you can clearly differentiate who and how much and in what proportions you want to receive probate property. It also gives you the ability to choose your executor. The executor is someone in a will that you nominate to be the head of the estate. So that person is tasked with filing all the appropriate documents with the court, liquidating assets, paying off any debts or costs or expenses that you may have, and then ultimately distributing those assets out to the beneficiaries in your will. And all of that is overseen by the probate court. Um, when you pass away without a will, it's called dying intestate. Intestate's just a fancy lawyer word, again, that means dying without a will. But essentially, the Ohio law provides that you can have a will and direct who you want to get stuff, how much stuff you want them to get, and who's in charge of your estate. Without it, we rely on other state statutes where the state's kind of chosen what they believe to be the majority opinion of how things should pass. So if ever you lose the ability to sleep, I would suggest you read Revised Code 2105.06. One, it'll educate you on how your assets pass without a will. Two, it's a surefire way to get some sleep. It goes through a paragraph A through like paragraph O and would say if you die without a will, your spouse inherits first. And if you've got a spouse and kids that weren't the product of that spouse, there's a whole allocation. And you get into some really weird distribution prongs. I had a gentleman a few years ago who wasn't married. Parents had both passed away and had no children. And he passed away without a will. And so we were asked to help with the estate. And in that statute, that revised code 2105.06, we were going through the different paragraphs to see what applied. It was spouse, nope, no spouse. Okay, kids, nope, no kids. Brothers and sisters, nope, none of those. And so we went to the maternal and paternal grandparents, who obviously were passed away by that point. But in order to go out on a family tree, you've got to go up first. And so this gentleman who passed away with a modest bank account and a piece of real property had 47 different heirs, because by that point we were into aunts and uncles, cousins, both first cousins, second cousins. So it took us about 2 years to administer that estate, mainly because we had to find 47 different people, get good addresses for them, and every time we filed something, we had to send it to 47 different people, some of whom had never met the gentleman that passed away. In that circumstance, he likely could have controlled more predictably who would have received his assets, and we could have avoided, that result. The other benefit of a will for people with young children. So, for example, I have an 8-year-old, a 6-year-old, and a 4-year-old. So we've got quite a bit until they become adults. And I'm at a point where they're my biggest asset. I don't have a lot of money. I don't have a lot of stuff. I'm not super worried about having the beneficiaries just right on my will. But what I am worried about is that if I pass away and they're under 18 and my spouse passes away, they're going to need someone to step in and take care of them. So through a will, that's the appropriate method under Ohio law to designate who would take care of any minor children for you if you and a spouse would pass away. Without a will, there's really no delineation or nomination of a person, and that can become somewhat problematic because Ohio law would suggest that any next of kin have the right to apply. And it's a weird thing, even something as simple as who's going to take care of, your kids could turn into a fight when you pass away. I've seen a lot of cases where, both sets of grandparents will file competing applications for who's going to be the guardian. And it should be as simple as we just need, two minor children to be taken care of. And it turns into a power play and something where we're looking at getting control and fighting through that process. So having a will is something that everybody should do because it's just so much more efficient to plan that out than just to let the state decide what happens. I'm going to skip ahead just a little bit. So again, a will is really the minimum you should do, not necessarily the maximum. So we had talked about how all property that passes through a will is called probate property. And we call it probate property for no other reason that it's got to go through the probate court before anybody's got authority to distribute it out to the beneficiaries. Um, yeah, so probate property is really any property that you've listed in an individual capacity with no beneficiaries listed, or it's the type of property where there's no trust involved either. So um, I think of the way that we own property as being important because the way we own assets can either give enough instructions to the person or the entity that holds the assets to tell them what to do when we pass, or we own assets in such a way where we don't give enough instructions and we have to rely on the probate court for guidance there. So, for example, if I own a house, I own real estate. That's the what in the two questions: what do you own and how do you own it? And let's say that I own that real estate individually. It's not owned with anyone else. There's no beneficiaries attached to that ownership, and I haven't placed it in a trust. Essentially, what I've done is I've told the county recorder, that's who manages the deeds that get recorded in a county and they keep track of who owns what real estate. I've effectively told that government entity, I own this property, which is perfectly fine and valid to do. So during my life, if I want to sell the property, I can. I list it with a realtor. When it comes to closing, I have the authority to sign the deed because I own the house. Where that becomes problematic is without any other instructions built in with how I own the asset, all the county knows is Joel owns this house. So if Joel passes away, the county still only knows that I own the house. They don't have any extra instructions that tell them what to do with it. They merely know that I've owned it and that I passed away. I think of that as kind of creating this gap. And I'll try to do this on Zoom. It's weird because I have a little camera. I can only see a little bit. But we have this gap where we know that I owned it. We know that it's got to go somewhere. But this gap in the middle leaves us with no good options because there's nobody living that can sign the deed to transfer it over because no one's got authority yet. And that's where the will bridges that gap. The will tells the court who to appoint. Once the court appoints an executor, that person now has the authority to sign a deed and sell that house. And then the will through the court also tells the executor who to distribute that money to after the house is sold. But it takes quite a bit of time to build that bridge with the will going to the probate court. Conversely, if I own that house and while I'm alive, I file what's called a transfer on death affidavit, I'm filing a legal document with the county that says, I own this house. And when I pass away, give it to Rachel, right? So now I've not only communicated to the county that I own the property, but also I've filled in that gap with instructions of what I want to happen with that property when I pass away. Because I've already built that bridge in how I own that asset, we're not going to have to rely on the will. The county knows, okay, if Joel's passed and we get a death certificate showing that he's passed away, we know to give the property to Rachel because that's how Joel told us to do that. So oftentimes you can leave assets to a beneficiary and that will overrule whatever you put in your will. So naming a beneficiary ties that beneficiary to that asset and tells the holder of that asset to give it to the beneficiary at your death. More often than not, most folks could plan with most of their assets by naming beneficiaries, so that the will ends up becoming more like a just in case document or a backstop. I think of the will as a backstop, the same as you would in a baseball game, where ideally we're hitting the target, which is our beneficiaries. And if we happen to have a ball that gets past those beneficiaries, the will stops it at the backstop and then gives it back to the beneficiaries. The goal being that we avoid probate, because probate, if there's no reason to go through it, can be somewhat time consuming and costly for the beneficiaries. So it's important to know what you own and how you own it for that reason. Um, as I said, most often people can just name beneficiaries. The alternate to that is having a trust. Um, so we'll skip through to that part. But on bank accounts, for example, it's called payable on death. So if you went to the bank and asked them to name beneficiaries on your account, they should give you a form where you can list those beneficiaries out, and then they attach that to your account. Um, Jointly owning property is also a good way to avoid probate. So in my case, I used with the real estate. Oftentimes, what we'll do with married couples is check their deed to make sure that it has the word survivorship in it. So let's say in that same situation, I'm married to Rachel and we both own the property together. Joint ownership with a right of survivorship communicates to the county, hey, we both own this, and if one of us passes, give it to the other. Um, I've had a lot of clients where they'll own property jointly, so they'll own real estate together. And for some reason, it's always, in these cases, it's always the wife that ends up dying first. And I get the grumpy old man who tells me, what do you mean I only own half of this real estate? I built this with my bare hands. It's like, that's true, but you did not do a good job on the deed. Um, if it doesn't have the word survivorship, the common practice is that each person owns 50% of that asset, and that 50% passes through their will when they pass, unless they've added beneficiaries to it. So, um, owning assets jointly with someone is a good way to make sure it avoids probate, as long as you've got that survivorship component in it. Um, but it's another way you can avoid probate without having to use a trust. Um, so we'll skip ahead quite a bit, because a lot of those slides, and they'll be available to all of you as well, go through some of the assets that are involved with what we call direct transfer assets. In other words, you've got a beneficiary named and it will automatically transfer to that person at your death. The other typical way that we try to avoid probate is by using a trust. Um, I get asked more about trusts than I do about anything. And a lot of it's because the legality surrounding trusts can be quite confusing. And there's a lot of misconceptions about a trust and who needs a trust. More often than not, I get the clients that'll come in and say, well, we don't have to talk about a trust because I don't have a lot of money. Um, in the past, it is true that folks that had some modicum of wealth would need a trust. A lot of that was based on estate taxes and where those estate taxes were. So pre 2012, Ohio as a state had a state estate tax. It's a lot of weird words to use together, but generally what it means is if you passed away with a couple $100,000 to your name, the state of Ohio is going to tax you based on that inheritance your beneficiaries received. And then the federal government also has an estate tax. And so, more than anything, we were worried about both of those taxes, and we used specialized trusts to try to mitigate both the state and federal estate taxes. Ohio, after 2012, got rid of its estate tax, and there are no signs that it's ever coming back, which is a great thing. And the federal government has a current estate tax limit of 12.9 million per person. So most folks, to get some benefit out of a trust as far as estate tax savings, typically have to be in the 12 to 20 million dollar range to even start considering it. So trusts are not just for people with extreme wealth. They also help when we have complex assets or complex beneficiaries. And we'll get into what both of those mean. But just to put it simply, a trust is a contract. So sometimes when you do a trust, it'll be called a trust agreement. And that's because under the law, it's most akin to a contract. And so in any contract, you're going to have multiple parties that agree on certain terms. Um, and so on the next slide, we'll break out who those parties are. So we have a grantor. So the grantor is the person that creates the trust agreement, they make the contract, and they set up the terms for how property that they put into the trust will be managed. The trustee then is the other party who agrees under that document, and their role is to accept the terms of the contract that the grantor laid out and to faithfully manage property under the blueprint that started by the grantor. The contract deals with how we manage assets and money for the benefit of beneficiaries that are named in the trust. In the most common trust, they're called revocable living trusts. Um, we get to poke fun a little bit at lawyers, which I'm always a fan of. So typically, the person doing planning is the grantor. They would also be the primary trustee when they start out. And during their life, they are also the main beneficiary. So if we recap all that together, doing a revocable living trust is like agreeing with yourself to give yourself your property to manage for yourself. That's something only a lawyer could come up with. But it works really effectively because if we have complex assets like a business, for example, I have a client that owns a business right now that employs about 200 people. Um, if the grantor of the trust who owns that business passes away, someone's going to need to step in immediately and be able to run that company so that they don't have a big delay in getting payroll out or making decisions about things within the company that allow the company to run day to day. So a trust is a really good way to allow someone immediate access and authority, but to also put in exactly what strings and conditions go along with that authority. So another example of a complex asset I have is I have clients who own an oil well that's currently producing about $200,000 a year of income. They've also got 9 kids. So their goal is for the kids to inherit that oil interest, but as long as it's producing oil royalties, they'd like that to be a blessing to the kids as additional income. So I should have made it 10 kids, but the truth is there were 9. I'm terrible at math, so dividing 200,000 by 9 is going to be a nightmare. But their goal is for each of them to share 9 ways in that $200,000 as long as it's coming in. At that point, when it stops, they're able to sell the property and the oil interest and then divide those proceeds 9 ways. With the trust, we're able to have those terms spelled out very clearly for the trustee. When we die, keep this oil interest and pay the net income every year 9 ways. Because we have it in a trust, the trustee knows to manage it the way we've told them to, and it works really efficiently. The other problem that we have is we could do a transfer on death to all the beneficiaries and avoid probate that way. But then we're putting 9 different people entitled to real estate and oil interests, and those 9 people plus their spouses have to agree on the back end to sell it. And so in that case, it could be a lot more problematic to pass it that way. It's much simpler to have one trustee oversee that interest on behalf of the other 9. The other place where trusts tend to be helpful is on complex beneficiaries. So a complex beneficiary is someone who maybe isn't old enough to manage the amount that you give them, someone who's not financially responsible enough to handle the assets they're given, or someone who's on government benefits like Social Security or Medicare or Medicaid, or someone with drug problems, someone that we just don't think could manage the money well on their behalf, or someone where if we just give them money directly at our death, they're going to lose a whole bunch of benefits or end up harming themselves more than helping themselves with the money. A trust is able to meet that scenario because through a trust, we control how our property passes even after we've passed. In other words, a trust is really the only way to put strings and conditions on those distributions so that we can protect our beneficiaries a little bit better. I always explain it this way. It's like if you have young kids. So, for example, I've got an 8-year-old, a 6-year-old, and a 4-year-old. If I pass tomorrow, I might not want them to have access to that money. I may not want them to have access at 18. You give $100,000 to an 18-year-old, they're going to be thinking, time to buy a Tesla, right? If you have that in a trust, they go to the trustee and say, hey, time for me to have a Tesla. And the trustee has the right to say, but I'm willing to look at Toyotas, So it's putting a filter between the beneficiary and their money, not necessarily taking that money away from the beneficiary, but having someone appointed that you trust to manage those assets for that beneficiary if they're not capable of managing it themselves. So with the estate tax line being around 13 million per person, we're seeing less and less people worried about doing a trust based on just money alone. And we're seeing more people needing trusts to meet certain family circumstances more than anything. And so a trust avoids probate because in that similar example we had used with me owning the real estate, if instead of owning it individually, I own it in a trust, when I record the deed into the trust, it's going to say Joel, trustee of Joel's trust, owns this property. And so when I pass away, the concern isn't, oh no, Joel died. What do we do with his real estate? It's Joel's no longer trustee because he died. Who's the next trustee in the document? Because the property is still in the trust. Even if you pass, the trust is still alive and well. And then we just click down the pages to see who's the next trustee and what they're supposed to do with that property. A lot of times we use trusts on a myriad of different circumstances with that. Sometimes we have cases where it's a second marriage and you have a house that's owned by one spouse and not the other. It's very typical for the spouses to say, well, if I die, I don't want my second spouse to get the property, but I don't want them to get kicked out either. And so typically through a trust, we can mitigate that risk by more particularly controlling how that asset's held in the trust. We're coming up on time. I don't know how much time you want me to leave for questions. But
yeah. Did you want to go ahead and start taking some?
Yeah, I can. The
Okay.
only other thing I was going to hit on that slide is there are also irrevocable trusts. Typically, an irrevocable trust, you're the grantor, you're making the agreement, but you're agreeing with a separate person to be your trustee. And those kind of trusts are typically used for asset protection planning or Medicaid planning, trying to get assets out of your name and control so that someone else can't count them against you. But that's pretty much all I've got. I'm happy to take any questions now.
I think you've got so much more in there probably too, but
Yeah. Yeah.
here's Jill's contact information. Any questions?
Yes. Hi, Mr. Cavanaugh.
Hi.
Hi, I had a question. So, if you have a house, if you own a piece of property and the property is only in your name, but you are married, is Ohio still a dowry state? And if so, would your surviving spouse still have a vestment in that property if you wanted to leave it to one of your children?
That's a great question. Ohio is a dower state, but dower works different than kind of how you think. So if your spouse owns property in their name individually and you're not on that deed, by virtue of being married, your spouse can't deed that property away during life without you releasing that dower right. In other words, that dower right protects one spouse from conveying assets away from the other spouse without that spouse's consent. Um, as far as passing away, the dower rights don't really protect anything at that point. And for a married couple, you'd still have to go through probate, because if the spouse that passed was the only person in title and there's no beneficiary attached, it's a probate asset under Ohio law. If it's only real estate, it's typically an easier time through probate, but there's no thing in Ohio. The only asset that applies to in Ohio are vehicle titles, and specifically motor vehicle titles. So if your spouse dies with only their name on real estate, you'll have to go through probate to get that real estate out. If they pass with car titles in their name, you would be able to automatically transfer those into your name. It's an unlimited amount of vehicle titles, but it's a total aggregate amount on the vehicles of 65 grand. So if you had 10 cars all worth $5,000, all in your spouse's name, and they pass, you'd be able to get all 10 titles out, no problem. If they died with one and it was like a Ferrari and it's worth 100,000, you'd have to probate that title just for that Ferrari.
So even so you still wouldn't be able to put like some so you could not designate it to a particular person. They would still have an investment in that property.
Yeah. So even if
Okay.
your spouse owns it and they want to leave it transferred on death to a beneficiary that's not you, you would have to release your dower right on that transfer on death affidavit.
Okay.
Yeah. It's very unforgiving. I had a client once that came in and said, you know, my wife had back surgery and she got hooked on pain pills afterwards, and she can't have any money because she takes it to the casino, gambles it away, or buys pills with it. And most of his assets were tied up in real estate where her name wasn't on it, but I couldn't even do planning for him because we couldn't move the assets into his trust without her signing off, and she just wouldn't sign off. So it's important to know how that's titled and deal with it, but they can't convey it away without you.
Okay, thank you.
Yeah.
Do we have any other questions? You can also put it in the chat box if you don't want to unmute your phone or your computer.
Yeah, this
I
is
do
Mike.
have a question.
Okay. Teresa, you go first and then Mike is right after her.
Okay, thank you. For the financial POAs, it sounded as though once those are in place, as soon as those documents are created, then they can be acted upon. It's not something that happens later when somebody's medically incapacitated or at any other point, correct?
Yeah, you're correct. There is a distinction. There are different powers of attorney, so each one is going to control by its language and its terms. But predominantly, attorneys in Ohio, we're using what are called the durable general financial. So it's effective from the minute you sign it till the minute you revoke it or die. We have some people that prefer what are called springing powers of attorney. And that's one where by the terms of the power of attorney, it'll say this is only effective on my incompetency. And then before the agent can act on your behalf, they have to provide a physician statement, more often than not from two physicians that say, yeah, Teresa is no longer competent. She can't act on her behalf. And then the power of attorney springs into effect. But it tends to be one where the benefits you get from having it effective from day one far outweigh the detriment to somebody being able to act on your behalf immediately.
Okay, thank you.
Yeah, great question.
Mike, you had a question?
Thank you. Yeah. What's the what do I look for when searching for an attorney to help me with this? Unless, of course, you're the only one, which will make it a lot easier.
Yeah, I'm the only one.
Okay,
Definitely
then.
the best in the state of Ohio. No, I'm teasing.
You're the man.
Yeah, so oftentimes I get asked to look for attorneys for people, whether it's out of state or just out of my area. Typically, I'll Google using the words estate planning. And the things I'm looking for on any attorney's website, it'll have practice areas. And if someone says, of course I do wills, I also do divorces and criminal defense law, and I do contract, I'm looking for a specialist, not a jack of all trades, master of none. So
Yeah.
if I start to see, and it depends. I mean, if it's a bigger firm, I would expect them to have multiple practice areas. If it's a solo practitioner or a smaller firm, I'm looking for that clear focus on it.
Okay. Okay. Thank you.
Yeah. Thank you, Mike.
I know we're winding down on time. Is there anyone else that has any quick questions for Joel before we wind up?
I saw one in the chat, and I'm just
Okay,
kind of
hold on.
figuring out how to use that. Wow, that's a lot of chat. Can a newer will overrule an older trust if the beneficiary wants it? So I'll delineate those. A will is going to control how probate property passes. A trust is going to control the property that comes under management of the trust. So theoretically, if you did a trust and you no longer wanted the terms and you did a new will that said, I'm leaving everything to Susie, not to my trust. However, you've delineated that asset to pass is what document will control it. So, for example, I have a bank account that I've got in the name of the trust, and I don't want it to go to Sarah anymore, who's my beneficiary in the trust. I want it to go to Steve, who's my beneficiary in the will. If I leave that bank account in my individual name and it passes through that will, it's going to go to Steve 10 times out of 10. Even if Sarah comes back and says, wait, you did this trust, I'm your beneficiary, I thought you liked me. Doesn't matter. It's not going to pass through the trust, so those terms will never control. If, though, I leave that bank account in the name of the trust, even if I do a new will that says I would roll in my grave if Sarah touches any of this money, if it's lined up to go through the trust, it's going to go through the trust and go to that beneficiary. It's the same thing with making beneficiary designations. So I have a life insurance policy and I've named Sarah as my beneficiary. And I do a new will that says I want it to go to Steve. The will's never going to control that unless I change my beneficiary appropriately. So generally speaking, a new will automatically revokes an older will that's inconsistent, and any changes to a trust you'd have to formally amend as well. So doing both is the best course of action. I hope that addresses the chat question appropriately. If not, let me know.
Great. Does anybody else have one last question we can probably take before we have to sign off? Oh, it does answer her question.
Cool.
Anyone else? Well, Joe, we really do appreciate you, first of all, for being patient with the fire alarmist, the main location, City Hall, for starting a little later. And hopefully our team has learned a lot. And I'm appreciative myself to having the information being told about this information. So, oh, yes, plenty of claps. So thank you guys so much. Your points should be to you by Friday, and then the upload for on the YouTube wellness page should be there next week. So you guys have a wonderful day, and thank you again, Joel and
Thank
Sarah.
you all. You all take
Have a
care.
good day.